Good morning. We will begin with the presentation of the colors and the Pledge of Allegiance to be led by Dennis Cannon of the Executive Committee of the South Carolina chapter of the American Board of Trial Advocates.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please remain standing as we sing our national anthem.
Welcome the Columbia Chorus to lead us in the national anthem, to be followed by a medley of patriotic songs.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Goes. Right, place. Hold. Mount.
Be seated.
Oh, beautiful for spacious skies, for amber waves of grace. transfigures you and me, as he died to make men holy. Let us live to make men free, while God is marching on. Hallelujah. Glory, glory, hallelujah. Glory, glory, hallelujah.
We're pleased to have the Chief Justice of the South Carolina Supreme Court, Jean H. Toll, who would like to address our James Otis Scholars.
Good morning, James Otis Scholars, and what a grand day this is for you and for me. You will carry this memory of celebrating the 800th anniversary of Magna Carta in this beautiful chamber the rest of your life. I want to take a moment to introduce the other state court judges that are present this morning. On the South Carolina Supreme Court, Costa Placonis. Costa, would you please stand? He's the Senior Associate Justice of the South Carolina Supreme Court. Also present is Chief Judge John Few of the Court of Appeals, Judge Paul Short of the Court of Appeals, and Judge Aphrodite Conduras of the Court of Appeals. Except for Judge Few, whose father is a lawyer, the rest of us did not come from families where it was even thought of that you could aspire to the legal profession. I hope I'm looking at a good many individuals who will one day raise their hand and take the oath as a South Carolina lawyer. And maybe even I'm looking at someone in this chamber who will consider becoming a judge and taking the vocation of bringing justice to all South Carolinians. And maybe even there is someone in this room who, as improbably as I did, from a place in the profession where there were only 10 women in the practice of law as I entered in 1968, I rose to become Chief Justice of the state. I hope I'm looking at a future governor, at a future Chief Justice, and I hope that many of you will consider, as you go back home after your education is completed, serving in these chambers. I sat in these seats for 13 years, perhaps the happiest years of public service. I hope many of you will join me in sitting in these chairs in the future as representatives of South Carolinians. God bless.
Thank you, Chief Justice Toll. We're honored to have here today the National President of the American Board of Trial Advocates, Mark P. Robinson, Jr. Mark is the National President of ABOTA. His father was ABOTA's very first president. Mark is a graduate of Stanford and received his law degree from the Loyola School of Law. He's the founder of the law firm of Robinson, Calcagni, Robinson, Shapiro, Davis Incorporated, based in Newport Beach, California. Mark has devoted his legal practice to consumer safety and has worked on thousands of products liability cases across the country, perhaps the most notable being the landmark Ford Pinto case, which resulted in a jury verdict for $128 million in compensatory and punitive damages. We are fortunate to have Mark here with us today. He's been on the road 3 weeks without being home. He is also one of the preeminent lawyers of our time. Mark Robinson, please.
Thank you, Sandy. You never know where you're going to end up here. And so you may end up being a trial lawyer. You may end up being a judge, as you heard. You just don't know. But this is a great opportunity for you. I want to tell you a story about me. When I was a 13-year-old boy, my father came to pick me up from school one afternoon, and he was driving me home, and then we diverted to downtown Los Angeles, California, where I lived, and we didn't go home. We went to a restaurant, and I was taken into the lobby of the restaurant. I had my books, fortunately, because my father went into a meeting with about 50 individuals. It looked like a constitutional convention of some sort. And I sort of tried to listen in, but I couldn't really understand what was going on. He didn't tell me what's going on, typical of some fathers, right? So lo and behold, I'd hear the word jury trial. I hear the governor, things like that. And after about an hour, one of the gentlemen in the room came out to go to the restroom, and he said, "Your father won." So I drive home with him that night, and I say, they said you won something. What did you win? He says, well, the governor in California wants to take away the right to civil jury trials for auto cases, which was most of the trials, the jury trials in California at that time. And he says, this really violates the Constitution of the state of California, which was derived from the 7th Amendment of the U.S. Constitution. And he said, we formed a group called the American Board of Trial Advocates, and I was elected the first president. And that began for me what you're doing here today. That began my civics education. I learned about the Magna Carta from my father. You know, I learned a lot about the 7th Amendment because I was the oldest of 8 children, and I was the person that he would talk to about this. And I think there's a reason he brought me to that first meeting of ABOTA. And I think this, that the ABOTA has gone from those 50 lawyers to 7,200 lawyers today. We're in all 50 states. We have 97 chapters. And our mission is to preserve the 7th Amendment civil jury trial in this country. So that's what you're getting here today. You're going to learn about from where this all came. And you're going to hear about the Magna Carta. You're going to hear about how what happened there in the Magna Carta applies here in our country, and how we're trying to preserve the civil jury trial in this country. And it is going down. The numbers are going down. The numbers are going down in my state. They're going down in this state. The number of civil jury trials are going down. And frankly, we need to get out a call to action. And frankly, we need to get to the American public, not just to us judges and lawyers. We're preaching to the choir. We need to get to you, to the young people. And that's what today is all about. So I thank you for attending, and I'm really proud to be here, and I look forward to hearing from you out there after we hear from all these great speakers. Thank you very much.
Thank you. And to answer the question that some of you may have, who was James Otis, is the National Secretary of the American Board of Trial Advocates, Chris Duggan from Boston.
Mr. Stern, Sir Robert, Justice Silber, Chief Justice Toll, Judge Condoris, honored guests, I know I've forgotten to name some, and most importantly, to our honored guests here, James Otis Scholars, thank you very, very much for having me here. It is a great honor for me to have a few minutes to address such an august body in a beautiful historic room. I've been asked to talk a little bit about who James Otis was and why it is that we call our program the James Otis Lecture. As a resident of Massachusetts, I could go on probably for 3 hours, but I've been told I have only 7 minutes, so don't worry. Otis was, in my view, the single most influential lawyer in American history. He was born in 1725, and he came from a small little hamlet, wasn't even an incorporated town at the time, of Barnstable, Massachusetts, which is down on Cape Cod. It had a total residence of maybe 80 or 90 people. That was it. He worked his way through college, went to Harvard, started a law practice with his father, James Otis Sr. And he read and studied deeply. He read particularly the works of Edward Coke, Sir Edward Coke, the great English jurist and Attorney General under Queen Elizabeth I, and Magna Carta. And it is so appropriate that we are here today to talk about James Otis in the context of Magna Carta, because Magna Carta formed the basis of Otis's worldview, the basis of the view of that freedom is necessarily governed by limited government, that there is a law that is above king and parliament. And that comes directly from Chapter 39 and Chapter 40 of Magna Carta and from the writings of Sir Edward Coke. Now, Otis was famous for a number of remarkable stances he took in the mid-1700s. He was one of the first lawyers, one of the first people to come out as saying that slavery is incompatible with freedom. He led the anti-slavery movement in Massachusetts in 1750. 1750. He was one of the first people to urge that all students, all young people, should be educated. And indeed, he was on the board of directors of the oldest school in America, Boston Latin. And he believed in free public education because he believed that no free government could work without an educated population. Otis was one of the leaders of the Stamp Act Congress. The Stamp Act Congress, which formed in 1765, in fact, it was his idea to get all the colonies together to oppose the Stamp Act because there had been no representation in Parliament when that act was passed. And Otis did not object to taxes, but he objected to the fact that taxes could be imposed on people who had no right of representation before the taxes were adopted. And that comes directly from Chapter 12 of Magna Carta. We shall not impose taxes except by common consent. But I've been asked to talk particularly, and what I think his greatest accomplishment was, certainly his argument in the writs of assistance case in 1761. Now let me talk a little bit about the background briefly, but what was happening. Picture this. The British Empire was just emerging victorious from the 7 Years' War. They had just taken virtually all of Canada from the Empire of France and incorporated it into the British Empire. An amazing victory. They ruled the seas. But the 7 Years' War had basically bankrupted the treasury. And so, to address that problem, the treasurer, Lord Treasurer, decided that it would be a great idea to tax sugar. And the reason this was important and is very near and dear to our hearts in Massachusetts. The sugar was coming from, in large part, from the Caribbean, the West Indies. But any molasses or sugar that was imported to Boston that did not come from the West Indies, from within the British Empire, would be taxed at double or triple. All of the molasses that was coming into Massachusetts at the time, or the vast majority of it, was coming from former French colonies and French colonies. Why was that important? Because molasses was used to make rum, and in Massachusetts, we loved rum. Seriously. The second reason it was important is that there was a man named Thomas Hancock. You may recognize the name. John Hancock's uncle, who weighed a fortune making rum in Massachusetts in 1758 and 1759. And if this Sugar Act was to be enforced, he and many other merchants were going to go bankrupt. And so instead of importing their molasses to make their rum through the Boston Harbor, where the people would go out and count the number of barrels in the hold. They snuck it in through Salem, Massachusetts, under cover of darkness. And they put it in the warehouses up there so that nobody knew where it was there or where it was coming. And so when those ships then entered the Boston harbor, the tax collector would go in and they would find a hold that was virtually empty. These were tax evaders. So when King George II died in 1760, the writs of assistance were then reissued by his grandson, King George III. And a writ of assistance allowed any person to go to the local constabulary and say, I think Mr. Hancock has rum hidden in his warehouse or in his barn or in his garage or whatever. And without any judicial review, without any review at all, the soldiers or the police could go into the warehouse or the barn of Mr. Hancock or anybody else and search the house with no judicial review. And it would cause a huge furor. Why? What's wrong with that? Many of these people, in fact, most of these people, were probably in violation of the tax law. Otis was asked to represent those merchants, there were 56 of them, when he challenged the writs of assistance. He, at the time, was actually Attorney General of Massachusetts. He was Queen's Counsel. He was supposed to argue in favor of it. But he resigned his commission so that he could represent Hancock and the other merchants and say the writs of assistance are wrong. Why? Because there was no judicial review. There was no independent review. And Otis made the point that if anybody could simply go into his neighbor's house and take over their yard or their barn or whatever, it would lead to a complete disintegration of civilization. Because if I did it to you, you would do it to me or my friends, and the next thing you know, we would have no civilized economy, no society, civilized society at all. And so Otis argued, he took the case, and he argued before the Supreme Court of Judicature in 1761 on February 25th. And he did so in a building that you can still see today, the old State House, which is right there on what was then called King Street, now State Street. And picture this. This guy from a little hamlet, a little backwater of the Commonwealth of Massachusetts, of the colony of Massachusetts, is facing 5 judges in their royal robes and powdered wigs, all of whom were appointed by the governor of the Commonwealth, approved by Her Majesty, His Majesty King George III or his predecessor. He took on the most powerful empire the world had ever seen. He faced the Chief Justice, Thomas Hutchinson, who was his dire enemy, and I tell you that Otis hated Hutchinson because he was a member of the oligarchy in Massachusetts. And Hutchinson hated Otis because he was this little backwater from no town and had no personal background at all. All Otis had for him were his arguments, his reason, his study. And he started with this. Your Honors, he said, I will to my dying day, and with all the faculties God has given me, oppose all such instruments of tyranny on the one hand and villainy on the other as this writ of assistance is. Now think about what you've just heard. You've got some nobody from some no place calling the king a tyrant and a villain. That gets you hung. But he did it because he was courageous. And at the side there, and one of the judges on the panel was also Peter Oliver, who was the brother-in-law of the Chief Justice. You can see sort of how incestuous this is. And Oliver sort of sneered at him and he said, Mr. Otis, how much is Hancock and these other people paying you for this? And Otis looked at him and he said, in such a cause as this, I despise all fees. Smart guy. Otis then rang off from Magna Carta up to 1750. Why this law could not be enforced? Because it was a violation of the law of the land, something that Magna Carta, chapter 39 and chapter 40, insisted that we shall not proceed against any person except by the law of the land. And Sir Edward Coke had mentioned in a case called Bonham's case in 1621 or something like that, that if Parliament passed any law in violation of Magna Carta, it will be void, setting the stage ultimately for judicial review in Marby versus Madison several decades later. Now, Chief Justice Hutchinson is looking at Otis with a completely blank face, because Hutchinson, who was the President of the Senate, the Privy Council, he was also the Lieutenant Governor and the Chief Justice, but he had no legal background. He had no idea really what Otis was talking about, and he didn't know what to do. So after the argument concluded, he sent away to London and said, "How do I deal with this?" Now you can imagine how the king must have felt about that. What do you mean, what do I do with this, right? You enforce it. That's what you do with it. There was no stenographer there in those days. But there was in the back of the courtroom a young 26, 27-year-old lawyer who was taking down everything Otis said in that argument. And that's why I could quote from the first part of Otis's argument, because he took it down word for word. Otis spoke for 5 hours, and he spoke without notes. And the young lawyer who was taking that down, he couldn't keep up anymore, so he summarized the basis of the argument. And that young lawyer, who was not a believer in separatism, wrote, "No, every person like me left that chamber ready to take up arms against the writs." That young lawyer, who was against separation, who was a loyal citizen of Great Britain, that day decided that it was time to set up a new nation and a new country. That young lawyer was John Adams. And John Adams, looking back on his great career, wrote a letter in 1806 or 1807 in which he said, referring to this argument, "Then and there, the child independence was born." And if you think about that, that means that independence was not won on a battlefield, was not won at Lexington or Concord or Saratoga. It was won in an American courtroom based upon law and reason. And that is why we celebrate James Otis, and that is why we celebrate the writs of assistance argument. Because this started the American Revolution. And what it really did was didn't start anything new, it was old. It was the belief, based from 1215 in June and Runnymede, that there is limited government, that all people, king and parliament as well as citizens, cannot violate. And so I look forward to the address, and I know that you're going to hear some great addresses, and I leave you with this from Sir Edward Coke. Coke wrote a bunch of stuff about Magna Carta and law, but he wrote this, which I think is particularly appropriate, in one of his last things that he ever wrote, called the Fourth Commentary. The epilogue was this: "I wish unto you the gladsome light of jurisprudence, the loveliness of temperance, the stability of fortitude, and the solitude of justice." Thank you very much.
Good morning, Madam Chief Justice, Chief Judge Few, members of our courts, honored guests, friends, and distinguished members of ABOTA. It is my pleasure today to introduce to you one of your guest speakers, Sir Stephen Robert Silber, the Honorable Mr. Justice Silber, who is here today visiting us from England with his lovely wife, who I believe is in the balcony. He has served on the Queen's Bench Division of the High Court of Justice of England and Wales since 1999 until his recent retirement. Sir Stephen received his knighthood in 1999 when the Queen appointed him to Her Majesty's High Court. Called to the bar at Gray's Inn in 1968, the Honorable Mr. Justice Silber has served as Queen's Counsel, as Deputy High Court Judge, on the Law Commission, as a member of the Employment Appeal Tribunal, as Gray's Inn Treasurer, and before that practiced commercial and employment law for 25 years. For those of you that aren't familiar with Gray's Inn, it is one of the 4 inns of court that lie at the very heart of English justice. To be a barrister or judge in the English courts, a person must be trained and be a member of one of the 4 London inns of court. The inns manage and regulate the entire justice system. And today, just to put it in perspective for you, a visit from the treasurer of one of these inns may fairly be analyzed to a visit from a United States Supreme Court justice. That he is coming to the States to see you is solely due and reflects upon the strong relationship between the University of South Carolina School of Law, our Chief Justice, and the judiciary with Gray's Inn over the past 15 years. Without further ado, it is my honor to present to you today the Honorable Mr. Justice of the High Court, Sir Stephen Robert Silber.
Madam Chief Justice, Judge Contouris, judges of the Court of Appeal, and other distinguished guests, and of course, most importantly of you, ladies and gentlemen in the audience. I'm delighted to be here in Columbia because we at Gray's Inn are very proud of our connections with your great university here in Columbia. These have been developed over a number of years by Professor Martin McWilliams of that university, and we're all delighted to see him here today. I must congratulate the organizers of this event on choosing the fascinating topic of the Magna Carta as a theme for this session. As I'll try and explain to you in a few minutes, its value as a source of legal principles has been seriously underrated in England, but it's had a massive beneficial effect throughout the world. The Magna Carta consists of a whole series of terms, most of which bear no relevance today, because they were dealing with tax and various other matters which were then causing problems 800 years ago. But what is vitally important is that the original Magna Carta contained 2 important provisions, and I'll read them to you because you'll be hearing more about them. They're very short. Paragraph 39, no free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so. And then the important words, except by the lawful judgment of his equals, or by the law of the land. The next provision of importance is very short. To no one will we sell, to no one deny, or delay rights or justice. When I first learned about the Magna Carta when studying history at school, I'd assumed that it was regarded at the time it was signed and in the immediate subsequent period as a document which had changed the whole course of history, as being a crucial document in setting out human rights in the 13th century. Further research has shown this is simply not the case. We now know it wasn't regarded at the time as an event which set out new principles. Sir James Holt, the greatest living expert on the Magna Carta, has explained Magna Carta was not a sudden intrusion into English society on politics. On the contrary, it grew out of them. Laymen had been assuming, discussing, and applying the principles of Magna Carta long before 1215. There is a very generally held view that as we're celebrating it 800 years on, it was never amended or revoked. That's wrong, because no sooner had the ink dried on Magna Carta when King John was urging the Pope to declare it void on the grounds that the barons had extracted it from him by duress. The Pope agreed to King John's request. Therefore, on the 24th of August 2015, just 10 weeks after its sealing, Magna Carta was declared null and void by a papal bull. Well, you might be asking yourselves, why are we celebrating it if it only lasted for 10 weeks? And the reason for that is that about 15 months after it was revoked, and after facing a baronial war, King John suffered a bout of dysentery, and on the 12th of October 2016, he died. He was succeeded by his son, Henry III, who was 9 years of age at the time of his father's death. So he had to have a regent. And he turned out to be the redoubtable Earl Marshal, a man who has made a great impact on history, not least of all because he rescued Magna Carta from obscurity by revising and reissuing it twice. Indeed, when his protectorate, Henry III, came of age, he also reissued it, as did his son, Edward I, when he became king in 1297. And it then contained the important provision that no man of what estate or condition shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death, without being brought in answer by due process of law. So it showed the vast importance of the due process of law, which is really shorthand for saying that to no one will we sell or deny any right or justice. These are the words which our great English judge, Chief Justice Cook, called a declaratory statement of common law. Now let's turn just to consider how Magna Carta was regarded in the centuries after 1215. Let's go fast forward to the 16th century. There's no evidence that it was regarded then, or even in Tudor times, as an event which would be celebrated 500 years later. Indeed, as we all know, William Shakespeare was fascinated by historical and contemporary events. You may have read, or you may have been reading at school when you do your English literature courses, some of his great plays, a lot of which are historical ones. They're accounts of major issues in the reign of kings such as Richard II, Richard III, Henry IV, Henry V, and Richard III. And he wrote his famous play, King John, in the 1590s. You would have imagined that Magna Carta would have formed a great part of it if he was just if he was dealing with the life of the king. But I wasn't able to find any clear reference to it. Now let's move a bit further forward to the start of this century. Among academic lawyers in England, Magna Carta wasn't regarded as important. I studied at Cambridge University and University College London, and neither place was Magna Carta mentioned except to those who studied legal history. It didn't form part of the basis of the English legal system. And indeed, certainly a year or two at Oxford University, undergraduates who studied constitutional law, I'm told, weren't taught about the Magna Carta. The attitude of practicing English lawyers to Magna Carta is interesting. In this country, quite rightly, but much to my shame in England, where the position is different, Magna Carta is frequently cited. In 1991, it was reported that more than 900 federal and state courts had cited Magna Carta. In addition, between 1940 and 1990, your highly revered Supreme Court cited it in more than 60 cases. In England, a very distinguished commentator carried out a search of the Westlaw UK base, which showed that Magna Carta was referred to in about 160 reported judgments over a period of about 450 years. I'll repeat that just in case you thought I got it wrong. 160 reported judgments in a period of about 450 years. Significantly, the writer Joshua Rosenberg hadn't found a modern case which had been decided solely on the basis of Magna Carta. I suspect that litigants in person tend to refer to it in an indiscriminate way. And the reason is that the basic principles have been incorporated into our common law by judicial decisions. It's interesting to compare the different approaches in this country and in my country, England, towards citing Magna Carta. It emerged very clearly in the litigation which had been brought in both countries by those who had the misfortune to be detained in Guantanamo Bay. The claims were slightly different. As the United States, the claims related to, among other matters, the right to habeas corpus. And in Committee and Bush, Justice Kennedy sitting in the Supreme Court and giving the masterly, if I may respectfully say so, majority judgment attached great importance to Magna Carta in finding for the claimants. In England, I was the nominated judge who had to try the claims for illegal rendition brought by the Guantanamo detainees. These were claims on the basis that these people had been wrongly captured, detained, and transferred to Guantanamo Bay. The case is actually settled with substantial payments being made to the claimants after lengthy hearings. There would have been much scope for citing Magna Carta as the liberty of the individual was at the core issue of the case. My recollection, which I've confirmed from people who appeared in front of me, was that it wasn't cited at all. Indeed, the parties relied on common law, but which had been developed from Magna Carta. And what has occurred in England is that Magna Carta was regarded as a springboard for masses of other developments. But we have tended to forget what the debt we owe to it. So when a person is detained unlawfully, we've adopted a remedy of habeas corpus, which means you go to the court and say you may have the body, which is used to obtain people's release. That owes its origin to those passages to which I've referred. Again, if a government body delays making a decision, the person adversely affected by it could obtain a prerogative writ to ensure that a decision was made. I could spend many hours giving other examples where remedies have been developed from it, but much to our shame, we haven't given credit to it. But putting the threads together, it has changed, Magna Carta has changed the legal landscape in England in many ways. And that's why we're so happy to be able to celebrate it next year. And indeed, one of the people who is at the forefront of it is going to be your main speaker this evening, Sir Robert Worcester, who has done so much to show the value of it. But can I just pull some threads together and see where what we have learned from Magna Carta? First, as I said, it's been used as the justification for remedies given to our citizens. Habeas corpus was described by our great legal historian, Sir William Holdsworth, in this way: without the inspiration of the general principle, with all the prestige of Magna Carta behind it, this development of habeas corpus could never have taken place. And equally, without the translation of that principle in practice, by the invention of specific writs to deal with cases of infringement, it could never have taken practical shape. Indeed, the specific writs which deal with abuse of power, such as delay and irrational decision-making, fall into that category. Second, as you all know, Magna Carta has been incorporated into many constitutions, and you'll hear more about that shortly, and also into the European Convention on Human Rights, which is the new basis for human rights, which was developed after the Second World War and has been adopted by all European countries. I think it's much less likely this would have occurred if it hadn't been set out so clearly in the Magna Carta to which I've referred. Third, Magna Carta contained a grant to all free men and women around the realm. In 1215, obviously not all people were free, but what was important, in the words of Lord Bingham, a former Lord Chief Justice, that Magna Carta was to an exceptional degree, it assumed a legal parity among all free men, thus contributing to a sense of community, which may perhaps help to explain Britain's happy freedom from bloody revolution since its civil war 350 years ago. Fourth, the Magna Carta represented a clear rejection of royal power. When it was signed, there was no parliament and power was vested in the king. But Magna Carta made it clear that such powers were subject to the rights of the individuals. It's interesting that it's formed a clearly expressed public statement which has been used as a basis of the coronation oath, which is taken by successive sovereigns when they accede to the throne in England. Finally, Lord Bingham made the very perceptive point that the significance of Magna Carta lies not only in what is said, but perhaps to a greater extent, what later generations claimed or believed it to have said. In other words, it's sometimes said that the myth is more important than the true position. It's been used as a rallying point in many cases where change has been suggested, and it's been therefore considered that rights would be affected. Of course, jury trial was in its infancy when Magna Carta was signed. But in England, if there are any attempts to restrict the right to jury trial, the response is that it contravenes Magna Carta. That is regarded as being a very powerful, if not overriding, argument. So I think I can finish by just saying, and I hope you agree with me, that Magna Carta is something that should be celebrated, and I thank this organization for organizing this event to celebrate this magnificent event. Thank you for being so patient.
Well, good morning and happy Constitution Day. I have said before, and I will say it again today, I hope someday at your high school, the person or persons selected to come to Columbia for the James Otis Lecture program will be held in the same high esteem as the person or persons selected to play in the Shrine Bowl football game. You are selected because you are great scholars, and you are to be commended and congratulated. You have a bright future, and we're proud that you can come to this program and learn and be inspired by those who are addressing you. I am Joel Collins. I am a proud member of the South Carolina chapter of the American Board of Trial Advocates. Today, I have the distinct honor to introduce my friend and a man to whom I admire, to whom I look up and admire very much. I've known Sir Robert Milton Worcester for a little over a year now. I have attended meetings in England where he has been the presiding person, because we were there at those meetings planning the great celebration which will occur on June 15, 2015 at Runnymede of the 800th anniversary of Magna Carta. Sir Robert is the Deputy Chair and Trustee of Magna Carta Trust, and he is the Chair of the Magna Carta 800th Commemoration Committee. A British newspaper writing about his appointment to this position stated, and I was proud to see this, that they could not have picked a more appropriate person to chair that committee. Sir Robert is a native-born American. He is from the state of Kansas. He graduated from Kansas University in 1955 with a double degree. He went to work for a big company and urged them to assign him to their London office. He had always had a fascination with London. In fact, told his mother when he was a boy that someday he wanted to live in this great, largest city in the world, most exciting city in the world, London. In 1969, he left his employment with the company he'd been with and formed a company known as Maury. It's the company that would be the rough equivalent of the Gallup polling organization. It is the Marketing Research Institute, Marketing and Opinion Research Institute, Incorporated. It now has over 1,100 employees. Sir Robert became a naturalized British citizen in 2004, and that same year he was knighted by Her Majesty Queen Elizabeth II as a Knight of the British Empire. He is also a freeman of the City of London, and I learned last night as we were talking that he is one of only 3 Americans who have ever been so designated as a freeman of London. He has been living, I believe, a life of service hard to equal. He is the former Chancellor of the University of Kent. He is a visiting lecturer at King's College of London, an adjunct professor of his alma mater, Kansas University. He has 6 honorary degrees. He is a man, ladies and gentlemen, who could have, at this point in his life, kicked back and decided to enjoy life, to enjoy his wealth and success, but who has instead traveled the world promoting Magna Carta and giving of himself. Many years ago, Edmund Burke, a famous member of Parliament, was called upon to speak at the dedication of a statue of William Pitt. William Pitt was a member of Parliament who championed the rights of the American colonies as they were seeking their independence. And at this statue, Edmund Burke said, "The means by which Providence raises a nation to greatness are the virtues infused into great men." I am proud to present to you a great man, Sir Robert Worcester.
Thank you, Joel. That was a very kind introduction, and I hope everybody else in the audience enjoyed it as much as I did. In fact, it was so impressive that I can hardly wait to hear what I've got to say myself. So I'm going to cover 3 things in this James Otis lecture, which ABOTA has organized. Why me? Why now? Why are you here today? You know what it is to be Americans, and my British friends tell me that Americans know more about Magna Carta than do the Brits. I doubt that, but I never admit it over there. What do you know about the role that Magna Carta played in the building of America and the impact it has had on the special relationship that exists between our 2 countries, America and Britain? Growing up in America, I had a pretty thorough education, schooling in English history, English literature, and not least English cinema, movies. Would you believe it? That was before television in Kansas City when I was growing up. Can you imagine what it's like to be without television? Well, you go to the movies an awful lot. I knew about the Angles and the Saxons and the Jutes, which then preceded William the Conqueror's 1066 and all that. And in 1215, I knew something about the charter we know today as the Magna Carta. For as long as I can remember, it was good King Richard, the Lionheart, bad King John, Lackland, and Robin Hood and his merry men, and of course, Friar Tuck, and Little John, and Will Scarlet, and don't forget Maid Marian. Skip to Henry VIII, Shakespeare, Elizabeth the Virgin Queen, 18th century Georgian, elegance in costume, in architecture and music. And I grew up with the belief that the sun never sets on the British Empire. And did I collect stamps from that British Empire? I sure did. My adopted country, now after 45 years living there, is Great Britain, which we can still today call the United Kingdom. Centuries ago, England and Scotland combined to form Great Britain 300 years ago. And in the last century became the United Kingdom of Great Britain and Northern Ireland, which now is called the United Kingdom. In Scotland just yesterday, people took part in the democratic process that we have in the countries that share the values that we found in Magna Carta. It may be the myth, but if it is a myth, it's the greatest myth ever. It's England's greatest export, and it is affecting and has affected the lives in over 100 countries throughout the world and meant a great deal to the lives of nearly 2 billion people. You all know that colonial America was a British colony. Nearly all the founding fathers of the American Republic were Englishmen. George Washington, the first president, John Adams, first vice president and second president of the United States, John Jay, the first Chief Justice, Thomas Jefferson, also President Benjamin Franklin, Charles Pinckney, James Otis, and many others. They were giants, but they stood on the shoulders of the giants of an earlier day, the barons and bishops of England, who forced King John in June 2015, 1215, I do that all the time, to renounce his absolute power over his subjects and abide by the rule of law. When delegates of the several states first met in the Constitution Convention to amend the Articles of Confederation in 1787 in Philadelphia, it resulted instead in an agreement by the people of the United States to build a country, and they were standing then on the shoulders of those earlier giants. Men who we've just heard gathered and knew not what they knew, but that they were doing when they gathered in Runnymede in armor, weapons drawn, to force King John to bow his head, he who ruled with the divine right of kings, forced to acknowledge that even a king who made his laws was still subject to the rule of law, a power greater than his own. Well, why me? Why am I am enjoying life, by the way, Joel, going around talking about Magna Carta. So let me explain a bit on the kind introduction to the talk about my relationship with the Magna Carta. On my first visit to Britain in 1957, I was a serving officer in the American Army Corps of Engineers. I was on the way home after serving in Korea, back to Kansas City, to be discharged, my tour of duty completed. On my first day in London, in England, I went to the British Museum to see two things: the Magna Carta and the Rosetta Stone. The Magna Carta because it represented the rule of law. The Rosetta Stone, which to me represented communication outside the village. These to me were the icons of a civilized society. When you follow in my footsteps, as I hope you will do someday, half a century and more later than I did, you'll find the Magna Carta in the British Library and the Rosetta Stone still in the British Museum. Go see them. I became a trustee of the Magna Carta Trust 21 years ago. I now serve as the deputy chairman, as you've heard, of the trust and the chairman of the 800th anniversary worldwide. You know, when I arrived in Great Britain in 1969, I found that I had lost the right to vote. Does that surprise you? It surprised me, because I still had to pay American taxes, but I'd lost the right to vote. And I remembered that in Magna Carta, those barons demanded no taxation without representation. So a group of us founded an organization we decided to call TEAA. TEAA. And for 3 years, I carried a tea bag around in my pocket. And I pulled it out on every occasion I could and said, it's just not fair. It violates Magna Carta that we have to pay taxes and we do not have the right to vote. Well, it took us 4 years to get up to a powerful congressman called Tip O'Neill. And we said, Mr. Speaker, we've lost the right to vote because we live overseas and we still have to pay American taxes. Now, there ought to be tax equity for Americans abroad, and we think you should choose either quit making us pay taxes or give us the right to vote. He said, you don't have the right to vote? That's outrageous. And I pulled that tea bag out of my pocket and I said, Mr. Speaker, if you don't, we're going to come and dump tea in your harbor. because he was the congressman from Boston, and his constituency was right on that harbor. So that's why I'm here today. But why are you here today? You're interested in the history of the country. That's a good start. You may be even interested in constitutional history. I was when I was your age. You may even become lawyers. Lawyers light up anywhere in the world that I go when I tell them that I'm chairing the worldwide commemoration of the 800th anniversary of the Magna Carta. Funny things happen to people of your age when you're looking at something or somewhere. When something happens to you and looking back on it, years later, you recognize that as a turning point in your life. It happened to me. It might be happening to you today, because in my case, I was taking part in a youth legislature when I was about your age, when I went to the state capitol and I sat in the seat of a state senator, and I introduced a bill, and I argued in favor of its passage, and I saw it put to the vote and won, knowing that if it had been real, which it wasn't, it would have changed people's lives for the better. And I hope that you'll come away today from taking part in this commemoration of James Otis and what he did, better informed about the history of your country and the role that a dusty document written in Latin nearly 800 years ago played in the development of what centuries later became the United States of America. Now, how many of you, let's see a show of hands, heard of the Magna Carta before you got involved in this James Otis Scholar program? Nearly everybody. Now, that's wonderful. I'm not sure in Britain today, if I'd ask the same question, I would have the same answer, because the awareness of people in Great Britain, only 6 in 10 of people your age said they were aware of a thing called the Magna Carta. More people of that age were aware of the Declaration of Independence and the Constitution of the United States than of the Magna Carta. Interesting. Sure, there are many myths which surround the Magna Carta, that it was only a fight between the barons and the king, that it was a peace treaty, and at that it failed, as you've already heard. It certainly was a fight, and the fight went on for several years. But the Great Charter lived on, reissued after King John's death by his 9-year-old son, and sealed by the guardian seal, probably one of the greatest Englishmen who ever lived, William Marshall, the Earl of Pembroke, who rode out to meet the 9-year-old son, to bring him into London and have as his first act the reissue of the Magna Carta that the Pope had annulled, and set his stamp there, which led then to his inauguration as King Henry III. It went on then, 1217 revised, 1225 by Edward I. Again, this has been mentioned in 1297, when it became English law following the establishment of a parliament. It was the beginning of the spread of modern democracy. It was the overturning for the first time of divine rule, the rule of King John, then, somewhat later, King George III's power over the American colonists, the beginning of a representative democracy. And as Lord Judge, the former Lord Chief Justice of the United Kingdom, recently quoted from the Magna Carta itself. Now follow me closely. Nullum scutagium, bel auxilium, patatur in rego nostro, nisi per commune concilium regi nostri. So who can translate that for me? Any takers? Oh my. No, now I don't see a single hand. Well, roughly translated in American, that means a phrase that I know you know now, if you didn't before: no taxation without representation. That was the cry of the American colonists, the sons of freedom, petitioning the king for their rights as free men, which led to the United States of America. It was the foundation of human rights, now still at home and abroad, under threat, as we consider how to cope with the threats that face us in the 21st century. It enshrined the rule of law. It limited the power of authoritarian rule. It paved the way for trial by jury, modified through the ages as the franchise was extended, and now what we call due process. Proclaimed religious liberty. The English church shall be free. For centuries, it has influenced constitutional thinking worldwide, including in many Commonwealth countries, in France, Germany, Japan, throughout Asia, Latin America, and Africa. Over the past 800 years, denials of Magna Carta's basic principles have led to a loss of liberty, of human rights, and even genocide taking place yesterday, literally yesterday, literally this morning, today, and I sadly report tomorrow. It's an exceptional document on which all democratic society has been constructed, described recently to me by the German ambassador to London as the foundation of democracy. For 8 years, Magna Carta has exerted a powerful presence and influence upon constitutional legal development, not least in America, but during the first half of that period, 400 years, only in the British Isles. But then in 1606, the Virginia Charter was signed in the Middle Temple by King James I, and 101 intrepid travelers departed Kent in England on the 19th of December, think of it, to sail into the North Atlantic to found the first permanent English-speaking colony in the New World in Jamestown, in what they named Virginia, in 1607, 13 years before the Mayflower. There's a scholar named Hazeltine, who nearly 100 years ago in 2017, who wrote in a book about the 700th anniversary of the Magna Carta, that Magna Carta is the most important phase of Magna Carta is its effect upon the Constitution and laws of the American colonies and of the federal union that was established after their War of Independence. He observed that with the Treaty of Paris of 1783, Great Britain acknowledged her former colonies to be free, sovereign, and independent states, and with that, the present period of national existence of America had its definite beginnings. He went on, this American evolution is one that rests for its foundation upon the long centuries of English development that preceded its own beginnings, and that bears also to a marked degree the imprint of constitutional and legal changes in England during the period of colonization and in later times. And we should not forget that the Englishmen who settled in America in the 17th century inherited all of the preceding ages of English history. To them belonged Magna Carta, the common law. Even today, American institutions and principles bear the impress of its influence. And this is also, to conclude, the reason for the existence of the special relationship that bonds my two countries, Britain and America. President Obama observed in 2011 in a speech to the British Parliament, our system of justice, customs, and values stemmed from our British forefathers. And he went on to say, our relationship is special because the values and beliefs that have united our people throughout the ages. Centuries ago, when kings, emperors, and warlords reigned over much of the world, it was the English who first spelled out the rights and liberties of man in Magna Carta. Over the next year, there are hundreds of things happening in America, in Great Britain, in at least 11 Eastern European countries, in Eastern and Western Europe, in Latin America, Asia, and Africa, to commemorate the 800th anniversary. And you can follow the commemoration of the 800th anniversary by signing up to the Magna Carta newsletter at our website, and tell us if you'd like to get involved at www.magnacarta800th.com. And I hope that some of you, and I've just learned this morning that your Chief Justice will be with us next year on the 800th anniversary, when several thousand Americans will be at Runnymede with the Queen and Prince Andrew and Catherine and probably Harry. But that hasn't been confirmed, because I was told by his private secretary that he's not sure what he's doing next week. Anyway, we're also going to have broadcast, so you don't have to be there. Over 1,000 people in Westminster Hall, a 1,000-year-old great hall in Parliament, 10 times the length of the width of this room. Oh, 1,200, possibly as many as 1,200 people, to see the mock trial of the barons and the bishops of 1215, up for treason, with the witness for the prosecution, bad King John, and the witness for the defense, a majestic figure, friend, Sir Robert Rogers, former clerk of the House of Commons. Somebody said to me, the House of Commons is representing the Lords? And I said, yeah, if it hadn't been for the Lords, there wouldn't be a House of Commons. And that's going to be broadcast live, as this broadcast today, on BBC World, and maybe even, I hope, PBS, crossed fingers. Thank you very much.
To lead our questions and answers that I hope you have brought with you is a member of the Executive Committee and National Board member, Sam Mabry.
Can everybody hear me okay? We're going to have now a sort of open question and answer session where the you students can come and ask either me or any of the panelists any question you want about, within reason, about today's topic, about what it's like to be a judge, what it's like to be a lawyer, what it's like to be a lawyer who's also a woman or an African American. Any question you have on those kind of topics. So your choice is to think up some questions and come up and ask them, or to stare at me for about the next 30 minutes, which I don't think is what you want. So if you got any questions, come forward, come probably to this microphone, and if it's a question that overlaps with maybe one of the panelists, I'll try to figure which panelist will answer the question. So come forward and let's start. Don't make me come out there. Yes, ma'am.
Good afternoon. My name is Antonia Adams, and I'm a senior at Strom Thurmond High School in Johnston, South Carolina. My question is, since the Magna Carta has so much influence on how our government is run today, how do you believe that current politicians and people in office can really implement this?
Robert, you want to take a shot at that one? Since you're born in the United States, but lived in England as well.
I'll be happy to take first crack at it, and that is, the first thing they can do is pay attention. And the second thing they can do is listen to their constituents. And the third thing they can do is broaden their horizons, because that's what the Magna Carta did, first for the people of England, and then on throughout the world, as I said, to over 100 countries. Now, these are values that are instilled in most Americans, but it seems that the ambition of many politicians exceed their concern for their own constituents. And in particularly America, the development of gerrymandering and the the fact that so many of the constituency boundaries are so configured that they guarantee re-election. You get people who, unfortunately, lose sight of the principles that they stood for when they were first elected. I hope that, Ms. Adams, is a good answer to your question, and I hope that somebody's listening.
Thank you.
Good question. Yes, ma'am.
I'm Brianna Bradham from Lawrence Manning Academy. And I'd just like to address this question to any of the justices here, or judges. Considering that the Magna Carta is from England, and obviously there was stated that many of the principles are in the United States Constitution and the Bill of Rights, how does that carry over to American law, and how can that be tried in an American courtroom citing the Magna Carta?
I'll let the chief take the first shot at it, but give Judge Honduras equal time. Okay.
It's a really good question. You know, the popular sentiment about the Bill of Rights is that it's a bunch of rules that protect the predator criminal. The popular mindset now is not at all reverent to the idea that individual rights protected against the majority is something that's really important. And yet, we got that straight from the Magna Carta. Now, I will tell you that judges of principle, and I serve on a wonderful court where we do what we feel the law compels, not what is popular. The Bill of Rights and its counterpart in our own South Carolina Constitution is foundational to any discussion we have of cases that are before us. We regularly see cases that involve the most heinous type crimes, brutal murders, brutal violations of anything sacred about personhood. And yet, if the rules of the road and the Bill of Rights are not followed, right to counsel, right to a speedy trial, your home is your castle, the right to not have that invaded except by due process and a proper warrant under the search and seizure clause. We regularly encounter those issues in a framework that's pretty tough, but we enforce the rule of law because we feel that that's what we took an oath to do, but we also really believe that those individual rights are foundational to societal order. So I tell you that I think the Bill of Rights is alive and well in the legal community and in the rulings of the judges, but maybe not so much in the hearts of the people.
Thank you.
You're not able to hear the question? Okay, well, we tried that. Can you guys on the podium hear from here? Okay. All right. Zach, come on.
My name is Anthony Merritt. I'm from Cross High School in Cross, South Carolina. And a subject you touched on was how many times the Magna Carta is quoted in English cases versus American cases. How is the Magna Carta viewed as a judge versus American versus English, saying how is it looked upon as a judge?
I'm going to let Stephen, yes, Sir Stephen, you take that one right here.
The point about the Magna Carta in England is, the effect of the Magna Carta in England is not that it's not regarded, or it's not used when people are talking about rights, because what has happened, it's been translated into a whole series of cases, but which all judges are bound to follow, such as habeas corpus, as being the way that people can be released. If the government delays doing anything, they can bring various writs, both in America and in this country. both in England and in this country. So it's really being moved on. It's being used as the major building brick for lots and the many rights which have been so well described by people like Sir Robert Worcester earlier this morning. So it's a building block which has been invaluable. But what is sad about it is people don't realize what the building block was.
Following up on that point, Judge Condouris, any time in your experience on the Court of Appeals that the Magna Carta has either been cited by a lawyer or by the court, directly cited?
I'm going to yield both to my Chief Judge and Judge Short because I can't remember a single time that I've actually seen it in print in one of our records. Have you? I don't think so either. I did want to follow up on the fact that in school, I went to school in Sumter, I can remember being taught about or of the Magna Carta in at least 3 or 4 classes before I was 18. I mean, it was something that routinely came up that you knew, as Sir Stephen said, that it was a building brick or a building block. But I can't remember, you know, it's now far back like the laws of Solomon or laws of Moses, where we all know, but so much has happened since then that is more the precedent we cite to.
Yes, sir. 2 questions. That's fine.
Following up on what you just said about how you heard about the Magna Carta 6 or 7 times before you graduated high school, and you mentioned, sir, that you noticed that everybody in here has heard about the Magna Carta, and 6 and 10 in Britain have only heard. Why do you believe that the Magna Carta is instilled more in the American education instead of the English education?
I'll let you answer that one, Sir Robert.
That's the second part of that question is very easy to answer. This is not a representative sample of American high school students. So if I had not seen every hand up, I'd have thought they'd got to the wrong room by accident because I expected that vote, and I was just making a contrast. But it wasn't really a fair contrast because if you take all 16 to 24-year-olds, which was the panel that we measured, I would expect it to be roughly the same. But watch this space, because we're going to do a survey in something like 21 or 22 countries to measure the awareness. In Trinidad, we've already got the results in Trinidad of the same question being asked, and awareness is only 10%. So there's a big job to do, and there's a brilliant professor named Hamid Ghani, who is organized 11 Caribbean countries to next month have a symposium of academics and scholars about the Magna Carta, but also an open lecture series in each of their countries. I'm going down and giving the first one tied in with the entire network of what they call the Open University of the West Indies. University of West Indies, I think, has 4 campuses in Barbados, in Trinidad, in Jamaica, and I think one other. But in all the Eastern European, English-speaking Caribbean, they have the open and an operation there that uses television to communicate to their citizens. So that opportunity and that platform is one that I value very much, to get to not very many people because they're fairly small countries, but to an awful lot of countries that the people are affected by the rule of law and Magna Carta.
Yes, sir. And you had a second question.
Yes, sir. This is for anyone up here. I don't know who would be able to. Without the establishment of the Magna Carta, how different do you believe our Constitution, our outcry for independence, the forming of our government, and consequently our nation would be today?
Chris, I'm going to let you, if you don't mind, commenting on that question, since you were really talking about the James.
We're still not hearing very well. So
Okay. The question was, without the Magna Carta and the principles in the Magna Carta, what effect would that have had on the American Revolution, whether it occurred, and on the American Constitution? In other words, how critical was that for those two historical events for us here in the United States?
A fascinating question. And the good thing about that, from my perspective, is I can say absolutely anything and I can't be wrong. The flip side of that is I can say anything and I can't be right. Your observation is brilliant, because Magna Carta was used to do one thing in particular, and that was to limit the power of the king. Several hundred years later, Sir Edward Coke, who I mentioned, decided that it not only limited the power of the king, that he could not go over the common law, the law of the land, but it also limited the power of the Parliament, and that any law passed by Parliament that violated the law of the land, the case was called Dr. Bonham's case, was void. That, in turn, was what James Otis relied upon in his argument in the writs of assistance case, that said the Sugar Act was a violation of Magna Carta, a violation of the law of the land. That, in turn, led to the American Revolution, if you believe what John Adams thought anyway. That, in turn, led to the Constitutional Convention in 1787, to the Bill of Rights several years later, because you know the Bill of Rights was not part of the original Constitution, and for all of the rights which followed thereafter. And the key thing about Magna Carta is its growth. It's an organic document. It's not staid. If you look at it, it's one long parchment. There's not broken out in the chapters. The scholars have broken out in the chapters, but it's just all in Latin. It's very hard to read, even for the scholars. But it has been organic, and it has been interpreted over and over, and each time has been to expand the rights of man. Now, what happens if we didn't have Magna Carta? My suspicion is that when you get to the settlements, the colonization, that sooner or later there would have been some separation, maybe not necessarily a political separation, but something different would have happened here, because our experiences were no longer 100% shared experiences. Things were different, but the people here in South Carolina who had to carve out a living, thousands of miles away from England, a different set of laws was required. But the fundamental laws were probably the same. And my guess is that the people in England, for whom we owe so much, and the people who set off our constitutions would have come up with something fairly similar.
Thanks, sir. Thanks. Yes, sir. This microphone's set up for me, obviously, so you may need to bend down and speak in where everybody can hear.
All right. Yes, sir. Wait, which one? Is this one?
Yeah.
Is it working? All right. I would like to get your opinion on this question. Seeing as the Magna Carta was created, enacted, and reissued long before the European system of slavery was considered to be a violation of human rights and morally and ethically wrong, as well as before the idea that those peoples displaced from their native land should be considered citizens of the state, do you believe that the Magna Carta is still an appropriate template for governmental power?
I think the question, Sir Robert, I'm going to let you take this one, and my understanding of the question is basically, given the fact that the Magna Carta was written, and this is my phrase, basically by white people for white people, is it an appropriate template to use for now? Is that the correct summary of it?
Basically, I guess. Yeah, you could say that. I mean, it's not necessarily a race thing.
Oh, okay. Well, I'm sorry. I misunderstood.
It wasn't necessarily a racially charged question. It's just asking, seeing as it was created before this system of slavery and before those people had rights, and now they're in the country, is the Magna Carta an appropriate template for the government to appropriate its power?
Well, I do think so, but I went voluntarily, and others were involuntarily. But I do think that it is still an appropriate document because there are 6 mentions of free men in the document, and that's been amended to be much more inclusive, obviously, today, including overseas Americans, whatever their color, because we certainly had no distinction. So we used it in argument with the Speaker of the House of Representatives, third in line to become president. If anything happens to the president and the vice president, it's the Speaker of the House who becomes president of the United States. And we used it because we'd been transplanted, most of us voluntarily, but some not so voluntarily, to a different country. And we used it, and so it was effective in the 20th century, and I see no reason it can't be useful in the 21st century for the rights of free peoples everywhere.
Yes, ma'am. Yes, ma'am.
You know, I think another thing you have to remember is that soaring words sometimes aren't played out, at least initially, in the decisions that are made about those foundational principles. And as Sir Robert has mentioned, the beautiful words that you've talked about of Magna Carta, about due process and the like, weren't replicated in the feeling of who they applied to. The word men was certainly taken to exclude people of color by specific provisions in the Constitution, as well as people not of the male gender. And over time, lawyers and judges were able to convince those in decision-making authority, and particularly the bench, both in this country and in Great Britain, that those soaring words had a broader application. For years, the 14th Amendment was not interpreted in such a way that it gave equal opportunity for all people to the same kind of education or even access to public accommodations. But over time, judges, and one very courageous judge in South Carolina, Otis Waring, who stood against the tide in the late 1940s and made the first ruling that segregation was per se unconstitutional. He based that ruling on 14th Amendment principles which traced themselves right back to 1214 in the Magna Carta itself. So it's a darn good question, young man, that you're asking, which is, you know, these beautiful words were in existence, and yet it took so long for them to be implemented. We're still in a struggle. We haven't reached the promised land yet in terms of what these words really mean. But citizens of good heart and judges of good heart will make it happen.
Thank you.
Hi, I'm Daisy Park from Lexington High School. Oh.
There you go.
Hi, I'm Daisy from Lexington High School. And I feel like in the public school system, we're taught that the Magna Carta is a building block, but I don't really feel like we're taught how it's important and why it's still relevant. And I just want to know, why isn't there being more done to promote it in the public school system?
That is another very good question. And we've taken steps in the United Kingdom to petition the Ministry for Education to build it much more strongly into the state school system in Great Britain, that now we're more following the German model, where they get the Magna Carta in the timeline when they're about 8 years old, and they get the philosophy when they're 12, 13. So they're not quite comparable, the two systems, in terms of the way they're structured, but we now have teaching aids. They're on our website that are designed for the British school system, but they're also going to be used by the British Council, who have offices in 192 countries. And that includes the United States. You've probably never heard of the British Council here, but they have offices in New York and elsewhere. But I don't think they're in Columbia yet. But nonetheless, they are functioning. They're very keen to promulgate this. and there's over 1 million people just in London who have English as a second language, and they've developed teaching aids for people who teach immigrants to the UK, and specifically to London, to use those teaching aids to teach them about Magna Carta, its implementation, and its value and relevance today. So the teaching aids are there. I know there are a number of the teachers that are here. We did have brought, and I think, Joel, that it's been distributed, Chris, Joel, who did the distribution of those packets?
I think we have them, yes.
Yeah, they've been distributed. Good, Sam. Thank you very much. So that the ones that I brought with me are not specifically teaching aids, but they're the website, www.magnacarta800th.com. You'll find the biggest repository of things to do, speeches that have been made, articles that have been written about the Magna Carta that has yet been in business, and it's going to be developed massively over the next 12 months so that teachers in all the countries, I'm sorry to say only in English at the moment, but hopefully the British Council will be translating some of them into places where the English is not the first language. While I've got the mic, let me just hold up some additional books that I value. There's one by University of Virginia professor, Dick Howard, that's entitled Just Magna Carta. There's this Oxford University Press called Magna Carta by Nicholas Vincent, who is the current outstanding living scholar. They're the two, one's American and one's British. They're both named the same, Magna Carta. There's a very interesting book by a chap I happen to know called Danny Danziger, and it's called 1215, because these other books tend to look from top down, from the king and the people, the barons and the people that were making the laws and in control. 1215 really looks at the peasants, and they look at 1215 and the Magna Carta, the year of Magna Carta it is, that is looking up at what's happening to folks like that. Just recently, an academic publication that I'm looking forward, it was only given to me Monday night and endorsed by Dick Howard, the University of Virginia chap. I saw his name on the back here, and it's called Magna Carta and the Rule of Law, and I hope that lawyers all over and judges will be looking into that as well as legal historians. There's a booklet on the first code of English laws that goes back to the 7th century, and that's just a little booklet. The Reverend and Valiant Vicar of the Temple Church in London has written London's Temple and the Road to the Rule of Law, and that is available and just about to be published in this country. It's already been launched in the American Bar Association edition. Is a marvelous, marvelous book that I'd love to see in every school library. It's a pretty expensive book, as you can see that it would be, called Magna Carta, the Foundation of Freedom. All of those have been published just in the last little bit to help educate, help develop, and help enthuse people who are as enthusiastic as I am about the rule of law and the Magna Carta. Thanks, Daisy.
Thank you.
I know the American Board of Trial Advocates has been very concerned about the fact that schools, not as much as at least when I was growing up, are not teaching civics as a real active part of the curricula. And I think Mark Robinson wants to speak to that issue or that concern, which I think is along the same line.
Yes, I agree. I think, Daisy, you raised a very important question. You said, how come you in your school, or maybe would this be true for many of you here? Raise your hand if you haven't really been taught in your schools, in your textbooks, about the Magna Carta. Anybody else? My gosh. Well, then maybe this is sort of a unique group here, I'll tell you. But the big problem, really, in this country, we feel, anyway, at ABOTA, is that there's not enough civics education throughout the country. When I was a young student, I took civics in school. And I think what's happened is we've moved away from civics education. And yes, ABOTA is supporting youth education, and we are trying to get ABOTA members throughout the country to try and meet with legislators and actually get back civics education in the core curriculum. But I think that's a great question, and we need that in this country. Thank you.
Let me take this gentleman and then your question next.
My name is Clay Anderson from Southside Christian School in Greenville. Judge Conduras stated that she couldn't remember a direct reference to the Magna Carta in the courtroom. Taking that into account, how important is it still to study the Magna Carta with regards to the profession of law and being a lawyer or a judge?
Chief Justice Toll, you want to take that question since you're basically all the lawyers in here's boss?
Well, I don't think you can really understand why the Bill of Rights was adopted, why it was thought that we needed to spell out those kinds of rights, unless you can understand the mindset that was a lot more directly referenced to Magna Carta than it is today. The revolutionists understood the tale of the barons in the fields of Runnymede staring down King John and getting a written document that would enunciate their rights, whether they were taxation, whether they were the right to due process in a trial, whether they were the right to be represented. Revolutionists understand that because that's what we were all about. We were trying to get a document, too, that spelled out individual rights in a context of a rule of law that really worked. I think it's pretty foundational to study it, just like I think it's pretty foundational to study ancient writings going back to the days of Plato and the Republic. We've got to understand a broader philosophical context for the rights that are sometimes taken for granted. I think a lot of people in this day and age that say, oh, the courts only protect the criminals and the predators, and these Bill of Rights, they're just technical rules that prevent us from convicting people when we need to convict them. If we're going to stand against that kind of mindset, we're going to have to understand our Bill of Rights in a very broad context that goes back to biblical times, that goes back to the most ancient enunciations of what it means to be a free man and be a free woman. So that's why I think it's real important. You lose your way a lot of times if you take only the popular slice of what has meaning and don't look at it in the deeper context of how people have struggled over mankind to come to very, very foundational principles of value. And the Magna Carta is there at the top of my list in terms of the rule of law. And I just say there's one more thing about that idea. You know, you all are special. You're the special ones. You've studied deeply already at your young age about the foundations of government in this country and around the world. So you know that there are many countries in the world that have documents of government that look just like ours. If you picked up the current governmental documents that describe the foundations of government in Russia and in many of the other countries of the world that have what they refer to as constitutional democracies, they look just like ours, but we know they don't work, and we know that many of them are descending into chaos. Why? Because the rule of law is not really the governing principle. It's might makes right. It's who you know counts. It's the influence of power and money. So they have a foundational document that looks a lot like our Constitution and a system of government that looks a lot like our tripartite system of government. But it doesn't work because the people don't really believe in the rule of law. And they don't stand against the easy opinion, oh, it's easier for me to get where I want to if I know somebody and I can have some influence because they'll think I'm special and do something for me, instead of thinking that societal order depends on those same rights being available for everyone, whether they're the best person you ever knew or somebody that's really got to struggle to be good, that these rights are foundational to what it means to be an individual and be a person. So, end of my preaching and speech.
We're coming to the end of the time on ETV, and I know we're coming to the end of our time as well, but everybody who's standing up, they're good questions, so we're going to take your questions. So, sir, we'll let you be next.
Hey, my name is Moses Washington. I'm from Denmark Ola High School, and I have a question for Sir Robert. And my question is that I know that you mentioned earlier that the Magna Carta is really important to like other parts of the world, including the Caribbean. In America, we tend to recognize the importance of the document here, but like, why is it so important to other countries in the world?
Good question, easy answer, and that is because it's the same rule of law. And if they live by the rule of law, just as the chief has said, then their rights will be protected in spite of what we all fear, which is the rule of the mob. The rule of the mob can make easy arguments at a time when there's a lot of media attention on something. And the example that I use to describe that is a thing called the Dangerous Dogs Act, because there was a huge amount of publicity about dogs that savaged a small child. And the Parliament just seemed to knee-jerk reaction to it. And they violated a lot. It's not that the dogs have equal rights, but maybe I think they should, but then I'm a dog lover. And it's that their owners did. And there were really draconian laws that were passed, which were on reflection pretty silly. But if we've got good, solid judges like the chief, then I think that they're going to stand up against that, and we don't have to fear, because they believe in what we believe in, and that's the rule of law in whichever countries that they are taking place.
Yeah, go ahead. I have a question for anyone.